I am, Your Honor.
And would you like some rebuttal time?
5 minutes, please.
All right, you got it, and you can begin.
And may it please the court, Donald Schutz representing Shirley Langston and John Langston. I'm asking the court to enter a writ of certiorari on the and grant my petition to allow me to sue these managers of an LLC now. I'm contending that we have the right to sue the managers for recklessness under section 605.04093 right now. The reason is that all of the elements for the cause of action have accrued, and there is nothing in the statute that prohibits us. Now, if I was suing a general partner in a partnership, no one would suggest that I had to get a judgment against the partnership before I could sue the partners.
Counsel, let me jump in for a minute. You started off, this matter started off as a 4-count or a 5-count medical malpractice claim. Is that right?
Correct, Your Honor.
And there's been no adjudication on that claim. In other words, there's been no trial, there's been no verdict, there's been no judgment, there's been nothing of the sort. It's just sort of been lingering around for quite a while now, correct?
Well, it has been lingering. That's correct. There's no judgment. We have not gone to trial.
What do these directors and officers have to do with medical malpractice? I don't believe any of them provided any medical care, did they?
They did not.
So isn't it accurate to say that the sole reason that all of these individuals are sought to be brought in by you is to enhance your ability for collection if and when down the road you're successful in your medical negligence case?
No, Your Honor. It's not collection. They're personally liable now because 6050493 says they are. It says that I can sue managers for damages. It does not say judgment. It says damages. And then what it says is, it's actually in the converse. It says managers are not liable unless, and then if you come down, it says they commit reckless misconduct. All the elements are present right now for them to be sued. It's the same thing as suing a manager, a general partner in a partnership. There's no difference. That is, you couldn't sue a partnership and get a judgment and 7 years later go sue the partner because the cause of action accrues as of the last element.
The recklessness that you're claiming has to do with their insufficient insurance coverage or insufficient indemnity or self-insured. It all has to do with collectability, does it not?
No, Your Honor. It has to do with violating Florida law and causing physicians to practice law or practice medicine in violation of Florida law.
Yeah, but the violation that you're claiming has to do with their improper or lack of insurance coverage or any ability for a successful claimant to collect against them.
No, it's a condition.
Let's make it more basic. It has nothing to do with them performing any sort of laser spine surgery or medical treatment of any kind. Fair enough?
I would say no. The part of practicing medicine is complying with the law, and the compliance with the law is 458.320. If you don't do that, you're in violation of compliance with the law. Say it again, Your Honor. So they caused their physician employees to violate the law. So it's not collection. I do not have to go in and get a judgment first.
Well, what is the law violation that you're alleging?
458.320. The financial responsibility law, they did not comply with any subparagraph of it.
It has to do with their financial responsibility, right?
Correct, which is a condition.
How can you try a medical malpractice case against physicians with physician experts and bring in and introduce evidence of whether or not they have adequate coverage or not? Isn't that the very thing that courts guard carefully against?
Oh, you could bifurcate the trial. I'm not saying the court could not bifurcate the issues and try the med mal before it tried any of these other issues.
Yeah, but did you file a complaint for violation of Chapter 405? Is it you simply filed a medical malpractice case?
Med mal case, Your Honor, yes.
So you're trying to meld a violation of 405 under a malpractice case, but the remedy for violating 405 would be injunction or something to compel compliance.
450. Is Your Honor referring to Chapter 458?
Did I say 405? Yes. You're saying they didn't comply with this financial responsibility chapter, correct?
So
So I'm asking you, what is your remedy? Your remedy would be to seek an injunction to compel them to comply. It wouldn't be to sue the doctors and say, oh, and by the way, you also violated. You'd have to have a separate count. What are you going to bifurcate? The relief requested?
Yes, Your Honor. Respectfully, what I sued for was to rescind consent. That's count 2.
Gotcha.
Rescinding consent.
But that count has now been dismissed as well, has it not?
That count has been dismissed. I've appealed that dismissal in 2020-701. This court dismissed that as from a non-final, non-appealable order.
Right.
I've moved for reconsideration for that. So on those counts where I'm teed up for that is that if the court denies my motion for rehearing on this court, then I've got to go to circuit court and ask for reconsideration. And if I'm unsuccessful on that, I'll have to try the med-mal case before I appeal that issue. But the point is that I have the right to sue these now. And in fact, I think you have to sue them now. The reason they have to be sued now is because all of the elements for the causes of action accrued. That is, I'm suing to rescind consent. There's no authority for the proposition that I cannot sue to rescind medical consent based on fraud. The case law is exactly the opposite. I've cited cases that say rescission applies to any contract.
But all those rescission counts, which is 2, 3, 5, 7, 8, and 10, those are gone. Counts 11 through 60 are gone. So you're back to a basic medical malpractice case at this point. Does a judge not have the authority to decide that these other claims don't belong alongside what I think Judge Stoddard referred to as not minimizing your case, but a garden variety medical negligence case? Can't he separate those out? Doesn't he have that authority?
Not at the pleading stage. I've stated the causes of action. They can definitely bifurcate them when actions are joined and separate them for trial. I would have no quarrel with the idea that I can sue them. The reason I have to sue them now, Your Honor, is because I don't have to sue them later. And I don't have to try to contend.
Well, before you jump to that statement, you're talking about what may or may not be an ongoing violation of a financial requirement statute, right? So you have to show a clear departure. And why is it a clear departure? Because you're not going to lose a statute of limitations argument. If they have an ongoing violation, the statute would not expire. So where is the clear departure in the judge saying, hey, leave well enough alone. If you want to make that argument down the road, I don't have to bifurcate it now. You can bring that back later if it's necessary. But if they cure the violation and they get this financial disclosure, financial statute complied with, where is the clear departure? Where are the damages? What are we left with? The malpractice case.
They don't go back and comply with it in 216. You can't do this retroactively. They violated the law in 216. They didn't have insurance, should not have been practicing medicine. They did not make the disclosures to my client. They are required under the statute to make written disclosures if they are not practicing medicine with malpractice insurance. Did not do that. I'm saying I can.
Alleged violations damage.
Hold on.
Say that again, Your Honor?
Atkinson's asking a question. Can you hear him?
I could not quite.
Okay. Judge, you're a little bit low, muffled. That we can hear sentences, but not real loud.
How did those alleged violations of the statutes requiring, for instance, insurance coverage damage the plaintiff in the med-mal case?
I heard alleged violations, Your Honor. I did not hear anything.
How does it
else.
damage the plaintiff in a medical malpractice? I think he said.
Just don't worry about it.
All right. He's willing to move on. If you didn't understand the question, we totally understand.
To the extent I believe that the damages are that my client never would have had surgery in the first place, but for the fraudulent non-disclosure of the lack of medical malpractice insurance and the fact that they were, we lost the judge, Your Honor.
Well, that's a video problem. I
Very
think
good,
that
The judge is still there, sir. You can continue.
Okay, he can
Thank you, John.
listen, but he can't respond. I assume he's okay with that. If not, there's 10 minutes left. We can keep going and then he can rejoin us when he's able. The tech
Very good, John.
person is on her way to try and rectify this.
Right. So I go back to the language of 605-04093. The right to conduct business without personal liability is not a common law right. It is not a constitutional right. It is defined solely by statute. So we look only to 605-04093. What are the elements to sue a manager? The element is that the manager is not liable unless they engage in reckless misconduct. The reckless misconduct here, as I've alleged, is that they cause their physician employees to practice medicine in violation of law. That's the reckless misconduct. Are all those elements now existing? Yes. When does a cause of action accrue? Under 95.031 Florida statute, a cause of action accrues when the last element constituting the cause of action occurs. Now, this course in the
But I mean, my question earlier relates to damages. There's two elements of damages that I'm having problems understanding. One is, how do you have damages for violating that statute before you have a judgment? Because if you had a violation of statute standing alone, that normally wouldn't give you the right to just file a lawsuit saying, I'm filing a lawsuit. You can file a complaint with the department.
Well, no, the department in the licensure issue, I'm not contending. I'm not suing to try to make them go get insurance.
But you only potentially have any sort of complaint if you have a successful litigation against a doctor who would then owe you something. You don't have that.
And nor is that an element of the statute, Judge. It doesn't say, the legislature could have said in 605-04093, the legislature could say a manager is not liable for judgments unless. It doesn't say that. 605-04093 says a manager is not liable for damages unless. Damages does not equate to a judgment. There's no case that says, every case that goes through an elements of a count says damages. Damages means an unliquidated claim. It does not mean a judgment. There's no case that says when a statute says damages, that means a judgment's a condition precedent to getting damages. So if the court looks at the Goodman case cited on page 21, 804 Southern 2nd, 544, that's a case where this court held that corporate members who are sued to pierce the court veil had a right to fully contest the substantive claim. So that's where I'm facing in this situation. I can sue to get a judgment without insurance. Then what I sue the corporate representatives. The response brief contends I can do it under 5629, which I disagree with. 5629 is purely for transfers. 5629 does not provide for any lawsuits other than transfers. This is not a transfer action. It is also not an action on a judgment under 95.11. 95.11 provides for actions on a judgment. And this case, in the National Auto Services Center's case, 192 Southern 3rd 498, specifically held that actions on judgments are not independent fonts of substantive rights and obligations. So there's nothing anywhere that says after I get a judgment against LSI, against Laser Spine Institute on the respondeat superior theory, that I can go start suing managers and members of that for either transfers, because I'm not suing for transfers. I'm not suing under an alter ego theory. If the court looks at the Turner case, which held that a post-judgment action could lie under the concept of an action on a judgment. In that case, it was a foreign judgment, 95.1.
I mean, do you agree with the proposition that if you go to verdict on the malpractice case and you get zeroed out, that it makes moot the claim for violation of the statute?
No, I
You
do not.
still think you'd have a separate cause of action because they violated the statute by not having the proper insurance.
The cause of action is rescission and battery. I don't have.
What would your damages be for violation of statute without underlying damages in the malpractice case?
It's not damages for underlying the statute. You have to have the cause of action. Turner says I have to have a cause of action. I can't just
All right,
sue.
listen, I've done you an injustice. I asked you a question as you were approaching the 5 minutes. You're now below the 5 minutes. If you feel compelled to keep going and providing more information, you're welcome to do so, but I'm going to count it against your 5. Or you want to stop and save your whole 5?
I would just as soon answer the question.
Go right ahead.
On Turner, what Turner did is it said that the cause of action accrues on an alter ego theory. But Turner also makes clear that you can't just sue to pierce the corporate veil. The cause of action I'm suing for is medical malpractice, separately rescission and battery. Those are the causes of action. They're liable under the theory of respondeat superior as employers, just as a general partner would be in a partnership. And I can sue them now because all elements have occurred. So it's not that I'm suing because they didn't have insurance. I'm suing because of their reckless misconduct that creates the battery, that creates the basis to rescind and creates
I
the
think
battery.
we get that point you're trying to make. We're having some technical problems. Here's my suggestion. I'll stop the clock.
Judge Landy, can you hear me now?
Yeah, and I'm going to let Judge Atkinson jump in and ask a
Well,
question.
can you hear me now?
Yes,
I hear you
yes,
now.
we hear you. He has a
Okay.
question. I'm not going to count it against your time, assuming it's not going to exceed a minute for the question and answer.
Well, it's probably been answered in multiple ways, but and so it's a general question that's been covered, but I was going to say what damage was caused what damage was caused by the alleged violations of the statutes that, for instance, require the insurance coverage to the plaintiff. But
I'm sorry, Your Honor.
I'm not saying you haven't covered that already, but that was going to be my question, just in case anyone was waiting with bated breath.
Succinctly as I can, Your Honor, the damages is battery. The damages is any damage that flows from battery. Had my client been told that they didn't have insurance as they're required to be told under the statute and required to be told under common law, my client never would have done this. Surgery without consent is a battery. And I don't have to go
I'm going to
through.
restart your clock now. I think
Very good, Your Honor.
you've answered his question. So you're down to 3.5 minutes. Again, you can keep going if you feel there's information you didn't provide, or you can save that for your rebuttal.
I'll just take 30 seconds if I can. There is no theory that a physician who violates the law and does not get consent should be protected under Section 766 requirements for suing for malpractice. The battery occurs when you don't have consent. And all I'm saying, Judge, is that when a doctor practices medicine in violation of law and fails to do the disclosures of that as required by statute, that's a basis for rescission that results in the battery. And for that reason, it's that the damages or any damage that will flow from a battery, and even without the battery, in the medical malpractice context, I'm suing for medical malpractice just as under the respondeat superior theory. Even if I lose on all the battery counts, I can still sue these managers now, right now, for reckless misconduct under the medical malpractice lawsuit. So either way, Judge, I have the right to sue them now, and I've made the allegations to sue them now. Thank you.
All right. I'm going to save you 2 minutes. That's what you've left yourself after all of that.
Thank you, Judge. That's fine.
All right. Miss Stein, you're next.
May it please the court, Diana Stein on behalf of Dr. Thomas Francavilla and Laser Spine Institute. Plaintiffs' claims that what were called the veil piercing claims are plaintiffs' creative attempt to bring collection actions into this garden variety medical malpractice case. The trial court saw right through it. He said these can wait for another day, and he exercised his very broad discretion. He didn't rule on the merits. He just said, you're not bringing 13 new parties into this malpractice case to talk about alleged financial violations.
What
They
about
could-
his argument that the court could have bifurcated that and shelved it until we got to that point?
Well, the petitioner is asking for this court to grant an extraordinary writ. And the fact that a court could have bifurcated something, first of all, doesn't even get close to the element.
Was there a motion to do that? Was that argument made below? Was it preserved?
There was a long hearing, and I don't recall. I mean, I think plaintiff made a lot of arguments, but what the court said was, this is so hypothetical that we're just not there yet. And the bottom line is plaintiff hasn't shown why the court's refusal to allow additional claims into this case is any different from the numerous cases from this court, from other courts that say the refusal of a motion to amend a complaint is not grounds for certiorari relief. Because
Well, I have a question. Let's just do a quick analogy. Let's hypothetically ask something by comparison. If you had a violation of the implied consent duty, the doctor didn't inform a patient what the risk was of a surgery, do you need to have a bad result before that becomes an actionable breach?
no, for a doctrine of implied consent, if it's against the doctor, I do not believe there has to be an actionable breach. This is what he's saying, is that by a third party who had zero to do with the medical care can be accused of some kind of actionable breach by causing someone not to be able to pay. This is much different than.
Well, no, I think he's saying they wouldn't have consented to the surgery had they been fully informed that they didn't have malpractice insurance.
I understand, and that is the case. The plaintiff alleged that count against Dr. Francavilla and Laser Spine Institute. Those have been dismissed. What plaintiff is now trying to do is what plaintiff was trying to do with the others is kind of another step and say, you caused them allegedly to not have insurance, and therefore you caused them to commit a battery or lack of informed consent. Those counts are out, first of all, so there's no sense in even having, considering those, the veal piercing counts at this point. But to take it a step further, there's no such cause of action. There's no cause of action that says, whether it be an insurance company that goes bankrupt, a self-insured that becomes insolvent, that there's a third-party action for causing someone, a doctor, not to have insurance. There is no such thing. If there was, the plaintiff could bring it in a separate action. The other thing I think that's important to understand is that what the plaintiff did is essentially cut and paste a lot of the allegations that are pending right now in another proceeding, and that is the assignment of benefit for the benefit of creditors proceeding. That's important because what the plaintiffs are really trying to do here, the assignee has brought all of these claims against the same parties. Now, I know plaintiff has dressed it up here and said they're personal to them because you made us cause a battery. But what the assignee said was what correctly is what plaintiffs are really trying to do is jump ahead of all of the other creditors, including other medical malpractice plaintiffs, in the assignment of for the benefit of creditors proceeding, and try to get the funds that the assignee has been trying now to recover from these claimants. Now, the court never got to the merits. He just said, again, you're not turning this medical malpractice case into a collection proceeding. This is something that could be done in a different proceeding down the road. And that's true. They can, had the court allowed the claims, I think the Moffitt case from the 3rd District, which appropriately follows bankruptcy cases such as the Bernie Madoff case, says creditors or plaintiffs simply can't do that. You can't dress up a claim, make it look personal to you, go after either a bankruptcy, the bankrupt party or some kind of a third
Well, is
party.
that runs afoul of the standard of review in this case? I mean, it sounds like you're saying there's no abuse of discretion, but the standard review is clear departure. So
It's
if he doesn't have a clear right to a cause of action for that statutory violation right now, how do we get to give him relief in this appeal?
Well, that's exactly right. He has to show a clear departure from the essential requirements of law. The court could have denied this on the merits on numerous grounds. He didn't. That would have been one of the grounds. The others being what Your Honor's asking about earlier, which is, are these even causes of action? There's no such cause of action of causing someone to not have insurance. If there is such cause of action, there is no requirement in Florida law, in any law that's been cited, that requires the court to allow these claims to be tried in this action. Yeah, and again, Your Honor's absolutely right. This is certiorari. He has to show a departure from the essential requirements of law.
Well, and isn't the court's decision exactly what's called for under Moffett?
Yes, absolutely.
There's been an assignment of these claims to another party that precludes this party from trying to jump to the head of the line and interfere with that. So now that there's been an assignment, as I read Moffett.
That's absolutely correct. And the assignee was concerned enough about these claims that he moved for injunctive relief in the ABC proceeding and made a special appearance in this case.
The bankruptcy lawyer, I think Mr. Stichter, showed up at the objection to the motion for amended complaint and actually made an argument to the effect of, hey, wait a minute, there's an assignment of benefits here. We shouldn't even be having this discussion.
Absolutely. And the point being that the plaintiffs don't have standing. I think that's how Moffett phrased it, to bring this action, because you're now impeding on the power and abilities of the assignee in that court to claw back assets to the estate or all creditors. That's absolutely correct. So going to a departure from the essential requirements of law, the court really was required to not allow these claims into the action. What he did was not get to the merits, which was perfectly acceptable, correct, and say, I'm exercising my broad discretion, essentially, to not allow these unrelated claims into the action because they don't belong here. What plaintiffs want to do is bring in, it's really what they want to do, bring in evidence into this malpractice case that show misconduct by in the financials of Laser Spine Institute, and these very complex veil-piercing corporate transfer of assets claims, which do not belong in this malpractice case, including, of course, Dr. Francovilla's alleged failure to procure insurance, which, by the way, there's been no finding that Dr. Francovilla ever didn't have insurance at the time he signed his papers to be licensed by the state. If he were to satisfy the judgment, or at least partially satisfy the judgment, he's not in compliance with the financial law 450. Section 5 says he can pay the judgment and satisfy the statute. So, again, we're talking about a lot of hypotheticals. We're talking about hypothetically, there is a medical malpractice found. We're talking about that plaintiffs successfully appeal the dismissed claims against Dr. Francovilla for battery and fraudulent procurance of informed consent. These may never come to pass. So again, the irreparable harm, the fact that this can be bifurcated, really just goes to the court's discretion. It could be bifurcated. It could be tried in a different case. Probably shouldn't be tried here at all because of the assignment of for the benefit of creditors proceeding. But again, the court just never got to that issue because he said, we're not turning this malpractice case into this complex financial case. Aside from that, I disagree that with plaintiff's position that there is an independent cause of action under the corporate statutes. I think this court in Connolly said that the business judgment statutes do not confer new causes of action. They simply address and limit causes of action otherwise brought against corporate directors or LLC directors. And again, this theory that a third party can cause a medical tort when they've never treated the plaintiff, it's, I would submit, creative but there's just nothing out there to support it. If we were to accept plaintiff's theory, then anytime somebody allegedly caused an insurance company or a doctor or whatever happens not to have insurance, that's a battery. And we know that's not the law. This can be tried on the merits. This can be tried on the medical negligence claims. We just don't need to get into all of these theories that the plaintiff has brought. And again, the plaintiff has remedies. The plaintiff separately filed an action already on the same claims, and the plaintiffs have claims in the assignment of for the benefit of creditors proceeding. They have remedies. As we've argued in the brief, they can certainly, if they still believe they have claims, either appeal them like any other litigant trying to bring in new claims in due course, or they could take the remedies that any litigant can do when in this procedural posture. So again, there's just no irreparable harm. I mean, setting aside the merits of it, he can't get past that hurdle of showing that he is going to be somehow precluded from bringing claims if they're not allowed to be brought at this time. So I would submit the court, for numerous reasons, was correct procedurally and on the merits. And in any event, in this extraordinary writ proceeding, plaintiffs can't show irreparable harm. They cannot show a departure from the essential requirements of law. I would respectfully submit that this court either dismiss or deny the writ and allow this action to proceed as it is at this time. If your honors have no other questions, I'll allow the rest of the time to plaintiffs. Thank you.
All right. Thank you, Ms. Schutz. Stein.
Thank you.
Mr. Schutz, you have 2 minutes left.
Thank you, Judge Black.
Mr. Schutz,
Sure.
if the surgery had gone swimmingly, yet the doctors, the LLC had failed to provide, no, let me change that. But the doctor himself had not had medical malpractice insurance, could a cause of action lie against him for
Yes.
battery?
Yeah, we could still, the battery.
What would the damages be?
The damages would be, Judge, we get punitive damages for battery. We can get nominal damages for battery. Battery has nothing to do with medical malpractice, and that's what the case law says.
But under Judge Atkinson's hypothetical, there's no negligence.
Well, the negligence, it's battery. It's an intentional.
So it's an
tort.
intent. So
It's an
So a
intentional.
doctor whose medical malinsurance practice has lapsed, who provides surgical services, and the surgery goes off without a hitch, can be sued for battery.
Well, lapsing is different than what happened here. My understanding of 458-320 is you have to, on renewal, make the representation. On renewal, he made a false representation that he had insurance. This isn't a situation where it lapsed. He obtained a license with false representations, did not disclose that to my client, and proceeded with surgery, which in my contention is that's rescindable and it creates a battery. There's a slight distinction, and I would have to look at the statute, Judge. I think there is an affirmative obligation to notify the Board of Medicine if your insurance cancels, but I don't know that. But in this case, that's not what happened. And Judge Black,
You've got a minute left.
Judge,
Yes, sir.
Judge, I wanted to respond to Moffitt. Moffitt was a transfer case. This is not Moffitt. Moffitt says you can't sue for transfers of corporate assets or derivative actions. This is a direct action against third parties seeking liability against the third parties to collect third-party assets. The assignee's claim is completely frivolous. If you look at 727-103, the only assets the assignee gets are the assets of the LLC, and that LLC does not own my causes of action. The LLC cannot bring my causes of action. The LLC cannot settle my causes of action. The LLC could never stop me from suing its former managers for reckless misconduct. I have a right to sue them now, and I believe I have to sue them now.
You're
I
at
believe
10
that-
seconds, just so you know.
Judge, I appreciate your honor's courtesies, and I appreciate you listening to me. Please issue the writ. I have a right to sue them now. That's what the law says. I'm just asking for Florida law. Thank you.
I want to thank you both. Well argued. We're going to take about a 10-minute break just because we want to make sure there's no technical issues remaining. And the 11 o'clock calendar is not for another 10 minutes. So we'll see you in a bit.
Did your honor want us to stay on?
No, you're done. You can watch.
Very good, your honor. Thank you.